topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show. Hey, this is our 16th year with Ask the Experts, and our expert today, this is the first Thursday of the month, our expert today has been with us for 12 years. Unbelievable. People love this show. Robert Kay, one of the principals in the firm, cannot be with us today, and he put in probably the best designated hitter ever. Let me welcome to the show. We've done shows together, board certified attorney Andrew Black. Good afternoon, Andrew.
Steve, thank you so much. I definitely have large shoes to fill. But I'm excited.
Yeah, you're sucking up, Andrew.
Yeah, no,
you're
thank you.
Sucking up. Andrew, tell people about K. Bender Rimbaum.
Absolutely. We are a full service community association law firm. So what that means is our primary client base are condominiums, HOAs, co-ops, all throughout South Florida. And we're on the association side of things. So any legal matter that a board may face, whether it's enforcing its rules, whether it's, collecting the assessments from the owners, reviewing proposed agreements, any general corporate matter, we're certainly well versed in that and can certainly help out all of those boards.
You know, I'm going to give you kudos because it is an incredible accomplishment. You are board certified. Tell people what that means.
Well, yeah, no, that's very nice of you to say. The Florida bar, they have pretty strict rules. You know, they don't want attorneys running around town saying we're the best at this, right? So they create a board certification, which is a very intensive exam process. It's also based on your practical work in that particular field. So in the area of community association law, I am board certified in that. Our firm has lots of other board certified attorneys as well, not only in community law, but also construction law, because oftentimes when you're dealing with high-rise condos, there's construction related problems there. And we also have a board certified construction attorney here as well. So all that means is we focus on this. We know our stuff.
And I can call you an expert.
I love that. Absolutely. Absolutely.
Hey, we had a pretty cool question, and I've never ever had this asked before.
Okay.
A listener wanted to know if it's a gated community, HOA or condo, does that mean it's an association?
Interesting question. What I can answer is whether there's a gate or not is not a determining factor on that. Usually, if there's a gate, that means that someone owns that common area property, right? And usually there's an association involved with that if it's a multi-family home. But the way you are able to know whether it's a homeowner association or a condominium is the original developer who owned that land. They created what type of structure he or she wanted way back when. So you need to review if there's any recorded restrictions against that land, ultimately to know whether it would be a condominium association or a homeowners association.
I'm going to go to our chat line because I
Sure.
recognize one of the writers. It says, on my HOA website, does it need to be password protected to get to the bylaws and the covenants, or is that public information? We only have 135 homes.
Got it. Great question. Those governing docs, the deck, the articles, the bylaws, those are actually public records. They're recorded in whatever county your community is. So that's not something that's private information. Certainly, if there's other community information, financial reports, emails for owners, those types of things, that should be under the password protected area of that website. But the governing documents themselves, I don't really have a problem with those being publicly available because they're recorded in whatever county you're in.
Next on our chat line, if a board votes on a monetary item, does that item and vote need to be on the agenda?
That's the famous question. You're asking the attorney. I'm here. I'm the specialist, Steve, right? So my answer will be yes, it should be on the agenda. The board shouldn't take formal action at a board meeting, such as approving a vendor, approving a contract without the notice and agenda clearly stating what they'll be doing that night. That way owners know I'm showing up to this board meeting. This is what I can expect them to vote on. And then the minutes of that meeting, that's the formal record of what happened, right? And the minutes are kept. So you can look back at the board meeting in 2023 in October. What did the board do then? And those minutes reflect what the board formally, approved. So in my view, that should be on the notice and the agenda.
Okay. And we always accept your emails and texts, which we get about 30 to 50 a month.
Wow.
Per market. When I say per market, meaning the Palm Beach market gets about 30. Actually, they get about 40 to 60, and Orlando gets about 20 to 25, and so does Tampa. We appreciate your question. Try to let us know, though, if you are an HOA or a condo. It does help with the questions. But I got to tell you, it makes my job so easy. I don't have to come up with questions for the show. We have enough questions to last us for the next 3 shows. So let's get started. We're going to go to
Sure.
Randy and Boca. Is there a unit in delinquency and has been turned over to the association attorney? Do the members still have the right to request a balance sheet of the delinquencies?
Got it. That's a great question. And I think what Randy's aiming at is, as an owner, do I have the right to see who's paid or who has not paid, right? Because
Right.
as an owner, paying your assessments on time, that is a very important factor, and that those funds obviously allow the association to pay for what its operating expenses are. Those account ledgers for the individual owners, those are part of the official records that owners absolutely have the right to inspect and request and C. So there's a common misconception out there, I think, because we get variations of this question quite often. But those account ledgers showing the payment history of owners, those are absolutely part of the official records that owners have the ability to see. Even if they've been turned over to the attorney, those account ledgers are still accessible.
Okay, we're going to go to Shelley on our chat line. Regarding the new law and board education, please confirm first year condo and HOA requirements. Then, how many hours each subsequent year of CEUs for condos and then HOAs?
Yeah, so there's been some confusion out there. The state of Florida, they modified the statutes for both condos governed under Chapter 718 and homeowner associations governed under 720, where there's new board member education requirements. And the goal is, of course, the more informed board members are, the better they'll be able to serve. For condos, new board members have to take a 4-hour board member certification course. That's a one-time 4-hour course for new members of your condo board. Those condo board members must also take on an annual basis 1 hour of continuing legal education. And the goal behind that 1 hour is the laws change each year, right? Lots of boards know there was a new House Bill 913 that was adopted effective July 1st. So condo board members, they have a 4-year for new board members plus a 1 year thereafter. For HOA board members, it's similar, but new HOA board members also must take a new board member certification course. And they also have a 4-hour annual requirement as well. So the goal is to encourage education. If board members don't timely do that, you're temporarily off of the board until you fulfill those education requirements. But you're put back on once you do. So they're not really looking to be punitive and really punish board members, but they're trying to put some, somewhat pressure on those board members to make sure they take their courses.
Okay, let's go to our chat line again. What is a reasonable time frame to post minutes of a meeting?
Great question. The statute doesn't actually state a specific time frame. So there's no law that says the minutes must be, approved and posted within 10 days. It does not say that. What happens usually is the minutes of a board meeting, they get formally approved at the next board meeting. And usually there's an agenda item that relates to that. Certainly, if you have minutes that have not been formally approved, they should, you could label them unapproved. And I think the board should be able to post those. Reasonable is a subjective word, but certainly I think you want to do it within that month. I think is certainly a timely way, if not a shorter time frame.
Well, we're getting a lot of Shelleys in today. Here's Shelley in Palm Beach. She is a condo association. She wants to know, we do not have Zoom or audio option. Can an owner set one up themselves without board approval?
Oh, that's a very interesting question. I always sort of laugh.
We get all kind of interesting questions on
this.
Here.
So before 2020, I would say the vast majority of people didn't really even know what Zoom was, right? I mean, it's like an unbelievable thing now. And obviously, during those COVID years when boards weren't meeting physically in person, Zoom became the thing. And lots of boards realized how much easier and there's more flexibility there. So they just continued offering Zoom as an option. The main thing from a legal perspective is boards are not required to make Zoom as an option. So if the boards don't, and the question is, can I as an owner record the meeting? The answer is yes. There's language in the Florida statutes and the Florida admin code that expressly provides owners the ability to record. It's subject to reasonable rules of your board, but those rules cannot prohibit the recording to, happen. The rules could, for example, make an owner submit written notice to the board a certain amount of time in advance, letting the board know that you intend to record it. But there's no reasonable expectation of privacy at an open condo or HOA board meeting. So a board member could not say, I don't authorize you to record this. That wouldn't be proper because the law does allow owners to record.
This is from Craig in Delray. Love your show. I live in a condo. Can the lawyer send an owner a cease and desist for requesting documents pertaining to a loan, a write-off that is related to past maintenance fees?
Got it. So the question is, can an attorney send a, adversarial cease and desist letter? The attorney can, but under that question, it's not suggested. If an owner is simply exercising his or her rights that the statute provides that owner, and those rights include the ability to request to have access to the official records, and a loan certainly would qualify as that, it would not be proper for the association to be essentially using its common funds, the engaged association counsel, to send that type of adversarial letter to an owner simply for the owner exercising his or her rights. And I want to point out, especially in a condominium setting, there was recent changes to Chapter 718 of the Florida statutes that prohibits an association from using common expense funds to have their attorney file formal legal action against an owner simply for an owner exercising his or her rights. So certainly that's something that if you're on a board, I would be cautious, and certainly your attorney should know that would not be a proper action.
Here's some, I don't know if this is a question, Ron. It says 718 requires more than one bid, and they have an exclusive service clause in the contract.
Interesting. Yeah. So I'm speculating a bit, but yeah. So if in a condominium setting, if the cost of the contract is more than 5% of what your total annual budget is for that year, you're required to get competitive bids. Competitive just means more than one. Lots of boards get 3. That's common practice. So you can see if one's too high or one's too low. There's some exceptions in the statute where you don't need competitive bids. Those include contracts with your licensed manager, your accountant, your attorney. So I don't know if that particular contract is one of those exceptions. If it's not, and the cost exceeds that 5% threshold, the board should be receiving competitive bids. So, obviously, I would need to see the exact language of the contract when you're talking about some sort of exclusive service rights. That might be just for the length of the term of whatever that service contract is for.
Well, some good news. people are writing on the chat line like crazy. So great
That's
job.
great.
Uh, Here's an HOA question. How can you tell if your reserves are statutory or non-statutory? Docs say nothing. How to tell if members voted?
That's a great question. So HOAs governed under 720, their obligation to have reserve funds is a lot different than condominiums governed under 718. HOAs governed under 720, the statute was recently changed that you only have what's termed statutory reserves is if, and certainly here where the documents are silent, only if the membership approved creating statutory reserves. That vote should be in whatever official records of your HOA. So if you're an owner, or quite frankly, if you're on the board trying to figure that out, you should be reviewing the official records to see if that official vote was ever done. If it was not, you likely don't have statutory reserves. You might call it reserve funds. Our suggestion is to avoid using that term because I think it creates confusion. And it's best to really identify those funds as simply a contingency account, basically a rainy day fund. So you don't give owners the misconception that those are statutory reserve funds that are restricted for just that reserve item.
Okay, so now a little behind the scenes. This is a live show. I don't know. You're in Pompano right now? Is that
I'm
right?
in the main office, Pompano Beach, sitting at my desk. You can see my files behind my shoulders. They're just calling my name that I gotta take.
Well, I'm
Oh,
in
yeah.
I'm in Palm Beach,
Okay.
and we are getting ready to get a major storm. So if we get knocked off the air, which you'll know, go ahead with the questions that we have there. But let's
Okay.
just keep our fingers crossed. We're good. Well, let's go to a break, and we come back. You got a lot of classes coming up.
Absolutely. Sounds good.
We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the Ask the Expert show. We are here with board certified Andrew Black of the K. Bender Rimbaum law firm. They've been with us for 12 years. This is the first Thursday of the month, so it's our South Florida show. We're here with Andrew. Boy, you got a lot of classes coming up. Hey, those new classes now are all 4 hours long now, right?
The condominium board certification is. So that's certainly one. We usually have two instructors, right, to split it up so people aren't forced to hear the same person. But yeah, we have lots of upcoming courses, all available on our website, kbrlegal.com. We have one on cyber security, which is great, about associations. You're dealing with owners' personal information. We had a question about an HOA website earlier. So some best practices. That cyber security class is September 10th at 12 p.m. We also have, I was mentioning earlier, for condominium board members, there's a 1-hour continuing legal education requirement. So we have a great condominium board member legal update next Thursday, September 11th at 11 a.m. The following week, the next Thursday, September the 18th, one of my favorite courses, I think it's just fascinating. It's navigating the fair housing laws, dealing with emotional support dogs and assistance animals, something that if you live in a condo or a HOA, undoubtedly you've had to deal with that. And that fair housing class is, again, September the 18th at 2 o'clock. And then the following week, we have a jam-packed month. September the 24th, we have an elections course. Florida loves its elections, right? And certainly in a HOA, co-op, condo, elections are very important. Certainly who's going to be on the board. And there's very, very detailed procedural requirements to ensure that your election is done the right way. And during this course, we'll go over that. That elections course is Wednesday, September 24th at 12 o'clock. And the two other courses for September, we have another condominium board member 1-hour continuing legal update course, Thursday, September 25th. That's at 3 o'clock. And the last one of the month, September 30th at 2 o'clock, we have a HOA board member certification course. So for those HOA board members governed under Chapter 720. So we encourage everyone. They're free, of course. You get to ask questions, learn about all of these wonderful topics. And again, more information is available on our site, kbrlegal.com.
What's the main number people can reach your office at?
Absolutely. We have a 1-800 number. It's 800-974-0680. That is our 1-800 number. And that's how you can reach any office. We have Pompano Beach is our main office. We have a Palm Beach Gardens office. We have a Tampa office. We have an Orlando office. So certainly we're spread out through the state of Florida. So any association out there, certainly we're well equipped to assist them.
Okay, let's get back to our hot chat lines. Can a condo board remove a board member for jeopardizing the community hoarder, or does the board require a vote majority from all members of the community?
Great question. And this probably is not a surprise to you or anyone out there, but board members don't always get along with each other, right? I mean, it would be wonderful if every board vote was a unanimous 100% in favor. But of course, that's a perfect world, and we don't live in a perfect world. And you deal with board members. Sometimes a board member goes rogue at times, right? And they do certain things that the other members of the board feel like aren't in the best interest of the entire community. So the question that we get asked a lot is, we're on the board. How do we remove this problematic member that's serving with us? And the answer is, it's not just a board vote. You actually do have to go out to the owners and get an owner vote for them to approve that removal. and that's called the recall process. And under the statute, you need a majority of all owners, which means 50% plus one of all owners need to vote in favor of that recall of whichever board member that is. And there are procedural requirements. So if a majority of the board is in favor of trying to accomplish this recall process, I think the board should get with their association attorney just to make sure all the I's are dotted properly, the T's are crossed, to make sure that you're following the statutory requirements. So long answer to say it's an owner vote, not just a vote of the board.
Okay, continuing with the chat line. If a proxy for an HOA election says all owners must sign, but only one owner signs, is that a proper valid proxy?
Good question. This is a little bit of a fact-specific type of deal because the governing documents for that community oftentimes has language dealing with if a home is owned by multiple owners, how is the home for that lot cast? Do they need a voting certificate on file, which basically means all owners sign a voting certificate saying all owners appoint one of the owners to be the official voting rep for that home. If your governing documents do not require a voting certificate for a home that's owned by multiple owners, and the proxy is signed by one of the owners, I would be inclined to accept it, even if the proxy may have some language saying all owners should sign. That instruction wouldn't match what the governing documents would say under my hypothetical. On the flip side, if you need a voting certificate on file, your governing documents require that, and the proxy is signed by someone who's not the designated voting rep, then I think there would be a basis to not accept that proxy. But again, that's a very fact-specific thing depending on what your governing documents say.
Okay, let's go to Cindy. Does Florida Statute 718 contain any rules and regulations for the use of common areas, such as painting and or storage of items underneath the stairway?
So the short answer is no. The statute doesn't get to that granular level about storage of certain items under a stairwell. What the statute states and what most governing documents state are that if you're in a condo, especially, the common elements are governed and controlled by the association. So usually the governing documents will have some language that restricts the ability of owners to store things under a common element stairwell. So yeah, I think that's usually the type of activity that could be regulated and restricted by a board.
Okay, let's go to Matthew. Regarding HOA meeting agendas, how specific do the agenda items have to be? Our board just lists generic items like new business, lawn care, interest gates, etc. They don't mention any votes.
Okay, well, the agenda doesn't need to mention specific votes. If it's a board meeting, that means the board will be addressing that agenda item. I agree that simply saying new business is not specific. It needs to be more specific than that. But if there's an agenda item that says lawn care agreement and you're dealing with a lawn care agreement, I think that would be just fine. I always advise boards, these types of issues are judged on a reasonableness standard. Yes, you could line up 10 people and you might get 5 that say this is reasonable and the other 5 that say something else, but it's usually judged on a reasonableness standard. So if you were an objective third party looking at that notice and agenda, would you have a sufficient idea of what items the board would be addressing? That should be your rule of thumb.
Here's a follow-up. Do they have to let us know of any potential votes so we can plan ahead? The statute says specifically.
So this person may be speaking about a meeting of the owners where the owners are voting on something. If that's the case, the notice and agenda for the meeting of the owners, absolutely, that there should be something that the owners are voting on something. And quite often there's a proxy included with the notice that is sent out that outlines what the owners are specifically voting on. If I'm misunderstanding the question and it's a board meeting where the board votes, there doesn't need to be specific mention of a vote on that because the board will be addressing whatever those agenda items are.
Here's another educational question. Another educational question is there, if there is a 5-year board member who had the option to read the documents and no class with the new law, do they now need to take the new board member classes as well?
Yes. So in our view, all board members, even if you were elected or appointed before the change of the law, need to take this education course. It used to be you could just sign what we call the Scouts Honor Statement, right? That just said, I'm on the board, I read the governing documents, I agree to uphold them to the best I can. And if you sign that Scouts Honor Statement, you would be fine. But the change of the law now is they're really pushing the education requirement. So yes, in our view, you would need to take that new education course.
And I want to thank everybody, our listeners, for all the great questions coming in. If a proxy for an HOA election says all owners must sign, but only one owner signs, is that proxy valid?
Yeah, so I think that's a bit going off on the prior question, and it's a document specific thing where we would have to see if there's a voting certificate requirement in the governing documents or not. And depending on what the documents say, then counsel for the association could make a more firm conclusion on that one.
It's kind of like always revert back to the documents.
A lot of the HOA and condo law really is document specific. You know, it's really every developer, when they own the plot of land and they decided I'm going to build a condo or build homes, they got to decide what restrictions they would put in when the community was created. It would make our lives easier if there was one set of governing documents, but that's just not the case.
Deborah in Boca Raton says, our manager says it's illegal to have an in-person interview for potential owners and renters. Is that true?
That's a great question. It's not illegal. What I believe the manager is likely getting at, which is, I think, a very good suggestion, is in our view, you should never condition approval of a new buyer or someone that wants to rent. You should never condition issuing approval based on that face-to-face interview. And the reason why is, if for some reason you have the face-to-face and then the board denies that applicant, it certainly could give the applicant more fodder to perhaps allege that there was some sort of fair housing discrimination going on. So to avoid any of that, because that's a very serious thing, because obviously boards can never reject someone on any constitutionally protected class, you know, race, national origin, gender, etc. Our suggestion, and probably what the manager was aiming at, is don't hold any face-to-face meeting with the applicant until the entire application is submitted, The third party background check is done. Everything looks great. You're ready to approve them. Then that face-to-face really turns into more of a meet and greet. Welcome to your new home. Here's the fob for the gym. Here's the rules when the trash cans get put out. So that's our advice there, is don't condition approval on that face-to-face meeting with the applicant.
Andrew, this next question must have come from your office. Should all contracts entered into by the board of directors be reviewed by the attorney before entering into them?
Is it
Must
signed
be from your
Andrew
office.
Black? Is it signed Andrew Black? Yeah, right. You know, so the short answer is it's a business decision of the board, obviously, right? And I'm not suggesting every sprinkler head repair for $200 you need to get your attorney involved with. What I can share with you is if a vendor breaches the agreement and you're, as an association, looking to file legal action, courts will only look at what's called the four corners of the contract. It doesn't matter what the smooth talking salesperson promised you, right? It matters what's on the contract itself. What was the offer that you as an association accepted by signing it? So if those contractual language doesn't adequately protect the association, you're really behind the eight ball if something goes wrong. So our advice is, of course, if there's any contract, if it's a service contract for any length of time, if it's any construction related contract, in our view, it's certainly best practice to have your attorney review it first. Oftentimes, your attorney can make suggested changes that better protect the association, that are still fair to that third party. I can share with you, certainly for service contracts, a pool maintenance contract or a landscape maintenance contract, a property management contract. I can't share with you how many times boards say, we're not happy with the vendor. We want to get out of this contract. And I say, send me over a copy of that. And I look for whether there's something called a without cause termination, meaning you could send like a 30-day notice to the vendor to terminate the agreement without cause. It could be because the wind blows a certain way. You don't need to prove that they did anything wrong. And oftentimes that without cause language is not there. So you may have a 5-year contract where you're locked in and you could only terminate early if there's a material breach by the vendor. And then oftentimes the vendor isn't going to raise their hand and say, you know what, you're right. We did something wrong. You can now go. That doesn't happen, right? They're going to claim we did everything right. And then you're left fighting with them. And it could turn into protracted, lengthy, expensive litigation that could be avoided if you have that type of without cause termination clause in there, which just is trying to get to my point. It's a good idea to have your counsel review those types of service contracts and certainly any type of, construction related agreement.
On an HOA, can a member get a copy of the unapproved minutes before they are voted on? And do they need to be on website before the meeting?
Right. So that's a good question. I think we talked a little bit about that previously. My take is somewhat of a more conservative one, but if it's a written record related to the operation of the association, that's the language that both 718 governing condos and 720 governing HOA says. If there's a written record related to the operation of that association, that's part of the official records that owners can see. So if there's minutes that have been drafted, even though they're unapproved, to me, it's more likely than not that that's a written record related to the operation of the association, and owners should have the ability to have access to those. Those minutes can certainly be labeled unapproved in case there's any changes to be made in the future.
I tell you, one of the things that we get from this show is we get a lot of questions about uh, not having enough members to run for the board. Here's one from
Yeah.
Greg and Davey. He said, if condo, if no one runs for the board, do you have to have an election? We have 121 units and we are lucky if 20 people show up.
Yeah, it's not an uncommon fact pattern. And honestly, I can see why some people would be reluctant to serve. First of all, I always joke, the pay's not very good, right? It's $0. It's a volunteer
Yes, right.
job. And oftentimes it's a thankless job. Owners, if something doesn't go the way they think it should, they blame the board. And sometimes, not always, sometimes owners forget members of the board are owners as well. They pay assessments just like the owners do. But it is a common problem, not enough people wanting to serve. And also, quite frankly, the Florida statutes have created lots of detailed requirements for board members to follow regarding record inspections and all sorts of things that makes compliance, I wouldn't say hard, but it just takes a lot of time. Having said that, you certainly want to make sure you can secure enough people to serve on your board, at least to have a quorum of the board to operate. Because if you don't, what I think one of the worst things that can happen is if you don't have a functioning board, is that any owner could file a request to have a court-appointed receiver to essentially serve as your board and do the job of what a volunteer board should do. That receiver has basically unilateral control to make choices that otherwise a board should make. And also a receiver gets paid. So the owners are now paying a third party to make unilateral choices for them when you really have the opportunity to have your owner volunteer board get seated. So anytime I am chatting with a property manager or perhaps a member of the board that has this problem, I say it's time to get out to the community, encourage them about how important it is to find people to serve so you avoid any type of receivership type of deal.
It's amazing, and we're coming to the end of the show. It's amazing that people complain about their board members not getting things done. When, if that's a problem, hey, run for the board, and help
Absolutely,
make
Steve.
decisions, right?
Totally. Absolutely. There's nothing that frustrates me more. If you have a genuine good faith board that's trying to do the right thing, if you're an owner and you're not happy with the way things are going, Steve, you hit the nail right on the head. Throw your name in the hat to run for the board, or how about volunteer for maybe to help the board? There could be a committee established to assist with certain projects to alleviate some of the burden that the board has. So I agree with you, Steve.
Well, I got to tell you, this show always goes by so fast. What a great job you've done today, and I hope you're going to come back again. I love doing the show with you, and we were inundated by people in the chat line today, so that's
great.
always a good time. Tell people again how they can reach the office.
Absolutely, Steve. I want to thank you so much. Again, our website is www.kbrlegal.com. Our 1-800 number, 800-974-0680. We have an email address, info@kbrlegal.com. kbenderlegal.com. You can just search us on any browser, K Bender Rembaum. You'll find all of those ways to contact us, and certainly look forward to hearing from you and hopefully possibly working together in the future as well.
Yes. Great job. Have a wonderful week. And I'm so glad we had you on today.
Thank you.
That'll do it for us today. That's attorney, board certified attorney, Andrew Black, K. Bender Rimbaum. They're also with us the last Tuesday and the last Thursday of the month. So 3 times each month. First Thursday, second Tuesday, end of the month, and the end last Thursday. That'll do it for us today.
Awesome.
Thank God we got through this weather.
Yeah, stay
We'll
safe.
see you all next week. Thanks, Andrew.
Thanks, Steve. Have a great night.
You too, bud.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.